Off the top tonight, special counsel Jack Smith put all his cards on the table this week in a 165-page court filing laying out his case against former President Donald Trump for his efforts to overturn the 2020 election. This is all part of an effort to convince the court that Trump is not immune from criminal prosecution in this case. One remarkable revelation relates to the evacuation of former Vice President Mike Pence. When Pence was getting evacuated from the Capitol and protesters made it within 40 feet of where he was sheltering in place, Trump's advisors told him about the situation. His response? So what? But at least one former Trump administration official thinks that filing this was a bad move strategically.
I think the optics of this are bad, but I think they're bad for democracy. Yes, we can talk about how they're bad for Donald Trump, but a lot of this is already baked in with Trump supporters. But what this can turn into, especially with Trump supporters, is them looking and going, okay, the fix is in. Here's the Biden-Harris administration one more time.
This may be the last filing we see in the case, depending on the election. Trump was given a small victory on Thursday when D.C. District Court Judge Tanya Chutkan gave him a 3-week extension to file his response to Smith. Now it's due November 7th, which is after Election Day, but perhaps still before we may know the results, depending on the vote counts. But if Trump gets elected, it is highly likely that he would fire Smith and his team on day one and punt on most filings. We'll take a closer look at the new details from Smith coming up with my guest in just a few minutes. And speaking of Trump's efforts to overturn Biden's victory in 2020, Trump's new running mate, JD Vance, dodged a question about it during the vice presidential debate this week.
I would just ask that. Did he lose the 2020 election?
Tim, I'm focused on the future. Did Kamala Harris censor Americans from speaking their mind in the wake of the 2020 COVID situation?
That is a damning non-answer.
Vance refused to answer whether Trump lost the 2020 election. Trump did. He lost. And both Trump and Vance refused to acknowledge the truth. That, combined with Republicans gearing up for an election fight in the courts, could mean that the 2024 presidential election is ultimately decided by a judge, or perhaps more likely, 9 of them. Republicans have filed over 100 lawsuits challenging election policies and procedures across the country, and that's after some judges criticized Republicans for filing similar lawsuits that were unfounded back in 2020. Recall, Trump himself or others on his behalf filed over 60 lawsuits claiming fraud. Most were dismissed for lack of standing, including by some judges that Trump appointed. But Republicans are not alone in developing a legal strategy to win the election. Democrats have also assembled teams of lawyers ready to challenge any disruption that they perceive. And now that early voting has begun in several states, prepare to see the legal fights ramp up. And speaking of 2020 election deniers, one of them got a 9-year prison sentence this week. The back and forth at the sentencing of former county clerk Tina Peters and the judge in this case was captured in the courtroom.
Good, good. Well, so you know what I'm saying is true. All right, let me move on. It's not funny. My life is on the line here, Your Honor.
No, you're the one who's making this allegation that, one,
it's
I think
not
is
an
funny,
allegation.
and two, that I know it's true. You're saying that as if I believe you, and I did not say that.
Peters was found guilty of facilitating a data breach scheme spurred by baseless conspiracy theories about voting machine fraud in the 2020 presidential election. And in August, a jury found her guilty of wrongfully granting an outsider access to the Mesa County election system. The judge had harsh words for her at her sentencing.
There are many things in my mind that are crystal clear about this case. You are no hero, you abused your position, and you're a charlatan who used and is still using your prior position in office to peddle a snake oil that's been proven to be junk time and time again.
Peters also pleaded her case to the judge to try and avoid jail time, saying she wouldn't have access to her magnetic mattress in jail, which she says she needs due to health issues. The judge didn't bite on that one. Meantime, a judge in Georgia this week struck down the state's 6-week abortion ban, saying it violates the state's constitution and its guarantee to liberty. Fulton County Superior Court Judge Robert McBurney wrote, quote, "Liberty in Georgia includes in its meaning, in its protections, and in its bundle of rights, the power of a woman to control her body, to decide what happens to it and in it, and to reject state interference with her health care choices." The decision comes after the state swiftly enacted a 6-week ban on abortion in the wake of the Supreme Court's 2022 decision overturning Roe v. Wade. 6 weeks is before some women know they are pregnant. But for now, the decision means women can have abortions up to around 20 weeks of pregnancy. The Georgia Attorney General has vowed to appeal the decision. And in 2022, the Georgia Supreme Court actually reversed McBurney's decision, striking down the law on separate grounds. So the court could swiftly put his decision on hold once again, pending appeal. The Supreme Court is now considering whether to take up a case out of Anne Arundel County, pitting county leaders against gun shop owners over the First Amendment. Gun shop owners like Worth a Shot off Veterans Highway in Millersville are challenging the county's requirement that they display leaflets on suicide prevention and peaceful conflict resolution. The First Amendment protects you from government censorship of speech, but it also prevents the government from compelling you to say something that you don't wish to say. The shop owners are arguing that the county requirement compels them to speak against their will and punishes them with up to a $1,000 fine if they refuse to comply. A district court judge, followed by a 3-judge panel on the federal appeals court, all upheld the requirement, reasoning that it's narrowly tailored to the government's interest in suicide prevention. The county had declared a public health crisis in 2022 after finding that suicides had increased for 5 years. Tomorrow is also the first Monday in October, and that means the Supreme Court will take the bench as the new term begins. On Tuesday, the court will hear a challenge to government rules regulating so-called ghost guns, guns without serial numbers. The rule requires manufacturers and sellers of ghost guns to basically comply with the same federal regulations that gun dealers and manufacturers are required to adhere to. A group of challengers out of Texas argue that kits used to make ghost guns aren't really a part of what Congress was thinking about when they granted the Bureau of Alcohol, Tobacco, and Firearms the power to regulate gun dealers and manufacturers. And in our area, as of this taping, the jury in Fairfax County has not yet rendered a verdict in the trial of former Fairfax County police officer Wesley Shifflet. Shifflet is charged with involuntary manslaughter and reckless discharge of a weapon for shooting and killing Timothy McCreed Johnson outside Tyson's Corner last year. Now, Johnson was unarmed and suspected of shoplifting sunglasses. Shifflet says Johnson was reaching into his waistband and he feared for his life. He's pleading self-defense, saying he was the most scared he's ever been in his life before pulling the trigger 2 times, landing a fatal shot in Johnson's chest. During trial, Shifflet's supervisors said he was doing exactly as he was supposed to do and what he was trained to do. They said officers don't have to see a weapon to fire on a suspect, but instead have to reasonably fear for their life. There's also a hierarchy of life that they're trained to consider when they're faced with a potentially deadly situation. Hostages, as you can see, take top priority. Witnesses and innocent bystanders, just under that. Police officers, they come in third, and suspects are last. Involuntary manslaughter. That's a crime of criminal negligence. That means prosecutors have to show that Shifflet had a reckless disregard for human life. That's like dropping a bowling ball off of a tall building or firing a gun into a crowded room, as his lawyers argued this week. Here's what happened that night.
Get on the ground! Get on the ground! Stop reaching! Stop reaching! Shots fired!
Shifflet's lawyers say any reasonable person would conclude from that footage that Shifflet intended to kill Johnson in self-defense. Combine that with the hierarchy he's trained to follow, they said, and he had regard for human life when he chose to shoot Johnson. Now, putting aside the arguments, this case has faced numerous procedural hurdles from the start. The first grand jury returned a no true bill, meaning they declined to indict Shifflet. Commonwealth Attorney Steve Descano had to call a special grand jury to get the indictment. And then a week into trial, the lead prosecutor had a heart attack. That led to a week-long pause. And then this week, prosecutors showed the jury a piece of Shifflet's body cam footage that they weren't supposed to because it was not entered into evidence. Now, Shifflet's team could have called for a mistrial, But they chose not to, and they're going to roll the dice with the jury. Let's explain a little bit what a mistrial is. It basically means tossing out the case entirely. If a judge declares a mistrial, prosecutors can then refile the charges and start all over again from the beginning. And there are a few reasons why judges declare a mistrial. Juror misconduct, like outside research on the case, that's a no-no, or when there's a hung jury. It's also possible when one side does something that prejudices the other side in a way that cannot be remedied. So if the jury delivers a guilty verdict, Shifflet's team could still ask the judge to toss the verdict based on the prosecutor's mistake during closing argument. But the judge cautioned defense that a motion after the fact, instead of when it could have been called for right afterwards, would face an uphill battle based on the case law. Also this week, the Georgetown cuddler finally caught. Ernesto Mercado, who lives in Arlington, is accused of multiple sexual assaults in off-campus apartments. This was between 2008 and 2012. The case had gone cold, but now Mercado is charged with 8 counts of sexual abuse. They say he would locate potential victims, sneak into their homes while sleeping, rape them, and then flee once they woke up. Police are asking anyone who may recognize Mercado to come forward as they continue to investigate cold cases.